Okay, good afternoon, everyone. I'd like to welcome you all to our webinar on financial services enforcement trends for 2023 and beyond. I'm Honor Levy, and I'm one of the professional support lawyers in the LexisNexis Financial Services Practical Guidance team. I'll be moderating today's session with my colleague, Eleanor Lamberton, who, like me, also specialises in contentious regulation. We're delighted to have here with us today our four panellists, Sarah Cody, Rob Dedman, Sarah George, and Guy Wilkes, who will all introduce themselves shortly. All four are well-known contentious regulatory lawyers who have extensive experience in investigations and in representing clients in regulatory enforcement actions. Most of them also have the added perspective of having had significant roles in the past in FCA or PRA enforcement. You'll be pleased to hear that we have a packed agenda today. The panel discussion will last for around half an hour, and we will then show you a very short video about our new financial services enforcement database. This will then be followed by Q&As from the floor. Please do feel free to start inputting your questions in the Q&A section on your screens, and we will try to get through as many questions as we can at the end. The questions won't be visible to all the participants, only to the presenters. This session is being recorded and the video will be available online afterwards. I'm now going to hand you over to our four panellists and to Eleanor to introduce themselves. Sarah Cody, perhaps you could go first, please.
Happy to. Thank you, Honor, and good afternoon, everyone. My name is Sarah Cody and I am a counsel in Linklaters Financial Regulation Group.
Hi everyone, I'm Rob Dedman. I'm a partner at CMS. In previous life, I was the first head of enforcement at the PRA.
I'm Sarah George. I'm a partner at Sidley Austin. I also have a regulatory background. I was a prosecutor for the Financial Services Authority between 2002 and 2006, and I now specialise in contentious regulatory work.
Hi, I'm Guy Wilkes. I'm a partner at Mishcon Rea. I also specialise in contentious regulatory matters, and in a previous life, I used to head a department at the FCA, working with Rob Dedman amongst other people.
Thanks, everyone, and thanks for joining us today. I'm Eleanor Lamberton, and like Honor, I'm a PSL at LexisNexis, and I'll be moderating the discussion today. So the object of the discussion is to identify a few of the key topics for FCA and PRA enforcement, rather than cataloguing all the potential issues, of which there are so many. So if we don't stress a particular topic you're interested in, then please do feel free to raise it in the Q&A. So kicking off today, let's discuss the FCA's recent announcement of Mark Stewart's replacement. So last week, the FCA announced the appointments of Therese Chambers and Steve Smart as joint executive directors of the FCA's Enforcement and Market Oversight Division. So Therese Chambers is an FCA veteran. She's been there for about 20 years and most recently as Director of Consumer Investments. And Steve Smith is joining from the National Crime Agency. So, sorry, George, if you can kick off, what do these appointments say about the direction of travel of FCA enforcement?
Well, firstly, that there are two appointments I think is very interesting. One of them, an internal appointment. Therese Chambers was actually the FCA contemporaneously with me. We sat together for many years. Even prior to that, she was in the enforcement division of one of the precursor organisations to the FCA. So she really has seen absolutely every possible angle to regulatory enforcement for the last at least 25 years. So I think it is going to be very much business as usual on the civil and the regulatory side, because she is not somebody who's going to have a learning in phase. She's going to hit the ground running straight away. I think that we will see a lot of continuity policies around early interventions on the enforcement side. But I think the appointment of Mr. Smart is very indicative of approach to the criminal side and perhaps money laundering and sanctions that's going to be very intelligence-led, given that's his background. So I think that will be very much more dynamic and a much more interesting development to watch.
Rob, do you have any thoughts on the new appointments?
Yeah, I also think there's a sort of an in-tray question, which I think, yeah, Sarah, you very rightly sort of raised the point that obviously Therese has been there for a very long time. For me, there's a sort of interesting question about what that appointment means in terms of the massive in-tray of investigations that the FCA has got and how it's sort of gradually, slowly working through those, and whether we might start to see actually a return to a slightly more normal level of investigative activity in terms of the number of cases being opened and then progressed in a more timely fashion. I think Therese has sort of lived through many different iterations of that enforcement process over her 25 years in the organisation. So she probably comes at it with a pretty good sense of what works and what doesn't in that context. And so to your point, Sarah, about hitting the ground running, there's something about actually not having to go back through thinking about all of those things again because she's lived through them in the past. I think that's quite an important part of that appointment.
Perhaps you could address how enforcement has evolved under Mark Stewart's tenure, and whether there's anything that you're hoping the new appointments will really address in terms of the internal workings of enforcement.
Yeah, I mean, Mark introduced plenty of changes during his tenure, some of which were very welcome, others perhaps a bit more controversial. As both Sarah and Rob have said, a big change was an increase in the number of cases under investigation. That has caused a lot of problems for practitioners in terms of delay. Also, I think the FCA has struggled in some cases with the sheer volume of work, and particularly got into tangles over disclosure, and we're seeing that continuing in some of the cases we're involved with, and I think we'll see more of that coming possibly from the tribunal in due course. Some of the changes, it will be interesting whether they will be kept in place or reversed to a certain extent. The focused settlement regime, I think, is very much welcome and will be maintained. I think what is possibly less welcome is the project boards that were introduced by Mark, and that meant that progress of cases was taken away to a certain extent from investigation teams, and it's been more difficult for practitioners to maintain a relationship with the investigation team, work out what's going on and get a sense of where cases are going. And so I'd welcome that being looked at, so that we can provide sensible guidance to our clients on things like timescale, what the FCA is looking at and where cases are going.
And Sarah, Cody, what about you? Do you have a wish list? What you hope Therese Chambers and Steve Smart might address in the upcoming years? So.
No, thanks, Eleanor. I think it's very interesting, actually. I think particularly having a data specialist up there, given, guys, you said the problems that we know the FCA has had in managing data in an investigation context. And I wouldn't necessarily call it a wish list, but what I think is very interesting is if you look at Therese's most recent role and the fact that was in consumer investments, looking at harms caused by scams and poor investments and unsuitable advice, I'm sure already has very strong views on how firms should be dealing with retail customers. And I think, given the sort of broader economic backdrop, I'm very interested to see what she does with that in an enforcement context, particularly given the large enforcement potential contained within the consumer duty, which will obviously come into force in a few months' time.
Yeah, and which we hope to address in this discussion coming up. So if I can just turn to financial crime. So we've just talked about Steve Smith coming from the National Crime Agency, which hardly seems surprising given the FCA's focus or enforcement's focus on market abuse and tackling those big increases in scams during the pandemic and AML and sanctions compliance. So AML has been such a hot topic for a number of years now under Mark Stewart's tenure. We've had the first criminal prosecution of a bank for breaches of the money laundering regulations. We've had a further high-profile fine at the end of last year against Santander for over 100 million. And just since the beginning of the year, we've had 2 more AML actions, in addition to the FCA bringing criminal proceedings for insider dealing and money laundering. So we have been highlighting this for so many years now, but I just wonder if there are any particularly new angles or developments around AML in the enforcement sphere, which we should be keeping an eye out for.
Well, I think that there are, and I'm just noting that the FCA sent a Dear CEO letter to payment services firms only very recently. That letter was sent to about 350 firms. In addition to concerns around safeguarding and prudential management, they specifically emphasize financial crime controls and money laundering and sanctions in that letter. So usually these letters are a precursor to where enforcement interest is likely to be in the not too distant future. And bear in mind, many of these are fintech firms that are new to regulation, often don't have a strong regulatory culture. They see themselves as as fintech, not financial services firms in many respects. So I think that's very interesting, as that is a development. And I think also what we are certainly seeing with the increased emphasis on sanctions from Russian sanctions, particularly from the war in Ukraine, that many firms, when they're having to report to OFSI, are also having to report themselves as well to the FCA under money laundering regulations. And that, of course, means that the FCA, which tends to be, has historically been a far more robust enforcer than OFSI has, is now getting the information. So I think we're going to see a great many cases arising out of that. And I think it's the FCA, I think, will start becoming the lead regulator on these areas.
That's really interesting. So that kind of know your customer systems and controls issues that are coming up with sanctions breaches are leading into AML systems and controls issues. That's really interesting. And Guy, what about on the crypto front and MLR registration and issues like that? Are you seeing anything of that ilk in the coming years?
Yeah, I mean, it's been an interesting period over the last year or two when crypto providers were doing business in the UK were required to register with the FCA, and it was particularly controversial because firms were finding it difficult to get through the process, and the FCA was not compliant with its own statutory timeframe for dealing with applications. Going forward, the Treasury has put out a number of consultations recently, looking to extend the scope of the FCA in crypto, and there's a clear direction of travel of, if you want to do business in the UK in that sphere, you are going to have to be registered with the FCA, or in due course authorised by the FCA when it becomes a regulated activity. And the FCA, and I think it'll be a while before we see the first sort of public outcomes. But clearly, crypto is a high risk area, and no doubt in the forthcoming years there will be many enforcement cases against crypto firms, both for AML and other measures as well.
And Rob, what about from the PRA's perspective, from a kind of financial stability perspective? I think there's been a bit more recently, certainly from the European regulators too, on issues with AML.
Yeah, I think the PRA has been on a bit of a journey actually on AML, in the sense that when the PRA was first set up back in 2013, there was a real sense within the organisation that financial crime was just something that was best left with Canary Wharf, as it then was, Stratford as it now is, and that the Bank of England, the PRA, were just not that interested in it. And I think that has changed actually fairly significantly. I think what we see, certainly from a supervisory perspective, far more regularly now, is the PRA supervisors being quite interested in the prudential risks associated with financial crime issues. And you see the PRA being a little bit more proactive in bringing those issues to the fore, and also in talking to other regulators about them. I mean, it's pretty clear that they talk to the FCA and to Ofsted about sanctions issues, for example, on a sort of fairly regular basis. So in that context, you can sort of see the PRA. It's never going to become front and centre because it doesn't have the financial crime remit that the FCA does. But if you're dual regulated and you've got a financial crime issue, you really shouldn't forget that the PRA is on the field of play, because it is.
That's really interesting to hear. And also, just if I can go back, sorry, George, to what you were discussing about sanctions. So what are you all seeing kind of with your clients around sanctions breaches and potential enforcement or even supervisory interventions there?
So from my perspective, we are seeing that the level of diligence done about ultimate beneficial owners has been very weak generally, and sanctions enforcement has not been a priority. But we're also finding whole other areas of issues arising in terms of correspondent banking, reliance on assurances of others, what the liability is when you process a great many transactions on behalf of an entity in good faith, and you're on reliance that they've been complying with their obligations, and you discover that in fact they haven't. We've seen very much how Scandinavia has had a whole series of major money laundering scandals, in the Azerbaijani laundromat being one example of them. And so it's really quite apparent that correspondent banking is only as strong as the weakest link, and there have been many victims.
I mean, just to build on that, the one thing that if I was sitting inside a compliance function at a bank that I'd be really concerned about is, and we've had this happen to a couple of clients, where the FCA has turned up and said, here are 500,000 names that we'd like you to run through your sanctions filter, please, to see what hits, and let us know what the results are. And I think that, you can kind of imagine how that is received when that is put into a bank context. That's a really slightly scary thing to have to happen in the current context, because you don't know what they're looking for. They will know the hits they're expecting, and so once you run those through and you don't return the hits they're expecting, you're in a sort of back foot conversation from the very beginning. And so I've sort of, a couple of clients I've had conversations with around that have been quite nervous about that as a prospect, for understandable reasons.
I think the other thing we're seeing is, obviously sanctions at the moment is an incredibly fast moving area, or a lot of grey areas. I think what has been disappointing is a lack of guidance from Ofsted on a number of these points. And even though they're the primary regulator for sanctions, we're seeing the sort of FCA stepping into areas really where I think firms would welcome more guidance from Ofsted on some of those difficult issues.
Well, I'm going to turn now to the next topic I'd like to address, which is assertive supervision. So, Sarah, Cody, perhaps you can kick us off. First of all, what does it mean, and how big a transformation is it from the FCA's traditional enforcement methods?
Thanks, Eleanor. Yeah, it's a really good question. So, I mean, effectively, what the FCA is doing is making greater use of powers that actually it's always had, and that we have seen for many years being used in different contexts, particularly actually in the AML context, where business restrictions are actually quite common in the context of investigations and enforcement. What the FCA said about a year to 18 months ago is that they wanted to take a new approach to supervision, and make more expansive use of these powers, and make more use of them on a real-time or sort of more frequent basis, so that they can be assertive and adaptive, and actually tackle harm, sort of when they see it arising, rather than allowing it to fester and to grow, and then only being able to deal with it kind of ex post facto at an enforcement stage. And we all know, the issues, we've already touched on them, that we've had with delays in investigations, and I think the FCA sees this as as a way of partly getting round some of those sort of systemic problems they have internally with investigations. So it's about using data more systematically to supervise firms and using these intervention powers more actively and pushing the boundaries and accepting a higher risk of legal challenge. Those were the FCA's words. And I think actually in the context of that, the decision that was announced at the same time as the appointment of Therese Chambers and Steve Smart, that they're going to consolidate the FCA's legal expertise into one legal function, that is, I think, quite interesting actually. And we see this play out in a number of ways. And we've talked about AML concerns and crypto asset providers. We've seen VREX being used to enforce past business reviews and redress schemes. And there was quite a lot of assertive intervention around the sort of British Steel Pension Scheme redress program. So I think there is a real lesson for firms here to be wise to this and to be aware that actually your supervisory discussions might not be as benign as they have previously been, and actually that situation could escalate quite quickly, particularly if you are talking about something which is an area of regulatory focus. I mean, Sarah said earlier, portfolio letters are a fantastic indicator of where we think enforcement is going. If the FCA is talking to you about something that is covered in a portfolio letter, you need to be alert to the fact that that supervision that you're experiencing may become a lot more assertive quite quickly. So think about preparing for this situation. How do you respond to that internally? What's your escalation procedures like? Are your business areas equipped and robust enough to deal with temporary restrictions that you might not get a lot of say in? And I think that's particularly important because these powers are public, but also there's far fewer procedural safeguards here. The FCA took steps to remove the RDC from the decision-making process. So these are purely taken by senior executives rather than having that separate decision-making committee that you have in an enforcement context. So there are real issues, I think, about the procedural safeguarding and the way in which these powers can be used by the FCA. So I think it's definitely an area to be keeping an eye on.
That's really interesting. So you preempted my next question of how these procedurals or lack of procedural safeguards are impacting your clients. And also just I'd be interested to know, we were discussing how long investigations are, but if you want to appeal one of these intervention decisions, how does that play out? Guy, do you want to?
Yeah, I mean, it's an interesting area because, people who've been doing this a while will remember Martin Wheatley and his getting in trouble for his shoot first, ask questions later comments. And lo and behold, 10 years later, here we are, and to a certain extent, it's being played out. Generally, the approach of the FCA will be to get the firm to agree to impose a requisition themselves, a VREC, and there's quite a lot of pressure on firms to do that. And in a couple of cases we've been involved in, firms have been on the verge of agreeing to it because they felt they'd got no choice under pressure from the FCA, and we've helped them push back. And actually, the FCA has, to a certain extent, been overreaching. But I think most practitioners did not welcome the removal of the RDC from supervisory decision making, and it does make things more difficult to challenge. I think clients have less confidence that they're going to get a fair hearing from the FCA when they do push back, and it is going to increase the number of tribunal cases. Now that may not be a bad thing, and it's something which Mark Steele has always wanted. Actually, he's always wanted more tribunal cases, so there's more jurisprudence and precedent that practitioners can rely on.
Just by way of adding to that, there's obviously a sort of a parallel to be drawn with the PRA here, because the PRA has never operated an RDC type process for supervisory decision making, and so it's actually quite a nice example of a scenario where one regulator sort of slightly flies under the radar because it never had it, and then the regulator that did have it removes it, and suddenly there's a massive outcry. It's just a really interesting observation that the PRA has been pushing things up to the Supervision, Risk and Policy Committee for years. And look, the same issues arise in relation to both. It's access to decision makers, visibility of the process. All of those sorts of issues arise in relation to both regulators, and they're difficult issues to advise clients on a day-by-day basis, because there is an air of unpredictability about that, in a way that there perhaps wasn't from the FCA perspective, with the RDC sitting at the head of that supervisory process.
George, do you have any final thoughts on the interventions that the FCA has become so keen on?
I think it's a realization that it simply takes so long to get matters through to the enforcement process, by which case, and the priority, I think, is very strongly shifted towards consumer redress. And we've seen this in some of the recent penalties. I think the recent Barclays and one of the payment services firms, I think the name escapes me, but where basically the intention was to get the consumer back in the position they would have been as fast as possible, and pressure was simply put on whichever party had the deepest pockets. And I think that is very much what we're going to see. The priority is redress schemes, not penalties 5 years too late to make any difference.
Yeah, and actually, Sarah, on that, and that's certainly a trend that we're seeing as well on our side, which is a bit of a sense from the FCA that they would far rather just get the redress program started and then think about the rest of it later, and leaning very heavily on firms, with threatening use of 166 and all of those tools that go with it, VREX, as Sarah Cody was saying as well, to try and get that redress program started as quickly as possible, with the enforcement stuff just sort of sitting in the background, sort of lurking nastily in the corner. And that's, we're seeing an increasing trend towards that, certainly on our side as well.
And I guess that focus on consumers and the retail side and redress is all the more interesting when you consider that the consumer duty is coming into force this July. So, Sarah, Cody, what are the enforcement risks that you anticipate here, especially in light of the cost of living crisis and the FCA's increasing focus on vulnerable customers?
I think it's really interesting, particularly picking up on Rob on what you just said around redress being the focus, because redress is so hardwired into the consumer duty. There are really positive, clear regulatory rules now for firms, or there will be for firms to think about, to be proactive in identifying harm, and then to be proactive about offering redress, and almost not waiting for the FCA to tell them. And as you said, Eleanor, the duty is being introduced against a backdrop of really significant cost of living crisis, a corresponding increase in the amount of customer vulnerability. So it's a heady time to be completely rethinking your approach to retail customers. And there's no question that the FCA has got a new toolbox of powers here, and it's going to want to use them. It does feel that there is harm occurring that it can't tackle without the duty being in place. And I think it's probably, this does dovetail beautifully with the assertive supervision piece, because I suspect what it will do early doors is go for the low-hanging fruits, go for the really obvious cases of harm, where this new suite of powers, coupled with the willingness to use the assertive supervisory powers, will give them a really good springboard to be tackling the types of things that you see in some of the portfolios, and the real kind of the sharp end of consumer harm. I think longer term, this is where it does get quite interesting. I think the open textured nature of a lot of the consumer duty rules, particularly think about the cross-cutting rules and this ability, this obligation to avoid causing foreseeable harm in particular, I think this does give the FCA a lot of scope for enforcement actions and for second guessing decisions that firms have made. I think the new framework also elevates an awful lot of material that was guidance into rules, regulatory rules, and the whole package imposes a higher standard on firms in terms of things like comms and customer support. So it's really fertile territory, I think, for enforcement. And we know that Mark Stewart's on the record as saying that it's that avoid causing foreseeable harm piece that he thinks is the problem in most enforcement cases, that in his view, firms don't stand back and they don't look at what the foreseeable harm is, and then they don't take steps to mitigate it. And I think that does actually have quite a big impact for firms in terms of implementation. because I think, you know, where we are now in terms of rolling out the duty in organizations of all types, you know, when we're working with firms, we're trying to use these lessons from previous retail enforcement to help firms build an approach to the duty, to rolling out the duty that puts them in the best position possible to withstand that future enforcement risk. Because there is a risk, I think, with outcomes focused regulation, that if you can't tell a coherent and well evidenced story about why your product offers good outcomes, why you met the consumer understanding outcome, etc., then you leave yourself open to the FCA making that decision for you, and almost certainly finding that, you know, you haven't met the standard that you think it should have. So I think, you know, I actually think that there's actually a lot of scope for disagreement as to whether the consumer duty has been breached. And I think some of that will probably end up being tested through enforcement cases. You know, I can definitely see that happening. I think it's a longer term risk just because of the time that enforcement takes. And as I said earlier, I think there will be, in the short term, you know, outside of that low-hanging fruit I mentioned, just a lot of pressure, even more pressure than there is already, to be on the front foot as a firm in terms of identifying harm and remediating it as quickly as possible.
Great. Well, thank you so much to the panel. I'm going to have to wrap up the discussion there so we have enough time for Q&As. And whilst the audience is considering what Q&As you have for the panel, we're going to play a brief video on the new enforcement database that LexisNexis has launched. So thank you very much, panel, and enjoy the video.
My name is Chris Bernard, and I'm in charge of developing financial services practical guidance for LexisNexis in the UK. I am excited to introduce our new financial services enforcement database. This powerful tool enables lawyers and compliance professionals to analyze data in relation to UK enforcement cases quickly and easily. Users can conduct targeted searches across hundreds of FCA, PRA, and PSR actions and filter results by multiple criteria such as rule breach. Research tasks that would normally take hours or days can be completed in minutes, saving time and money and freeing you up to focus on other tasks. The database can help lawyers advise clients who are or could become the subject of an investigation by analyzing how regulators have responded to a specific set of facts in the past and what factors they are likely to consider when calculating penalties. The database also enables lawyers to understand the enforcement priorities of the UK regulators and develop systems and procedures that will enable clients to avoid becoming the subject of an enforcement action in the future. If you'd like to find out more about how you can access the LexisNexis Financial Services Enforcement Database, please get in touch.
Enforcement database, which we've just been playing a video on. This is a sort of pre-prepared search that I've done, and I'll explain what I've done in order to get up all of the AML systems and controls cases that the FCA has issued since 2014, when that's basically as far as the database goes back at the moment, the 1st of January 2014. We are intending to backfill it. So I've applied the filters here so that we can see FCA cases from the beginning of 2014 to today's date. All the cases involving individuals and firms with the keyword anti-money laundering systems and controls, and also searching across all cases which include either the money laundering regulations or CISC 6.1.1, which of course is one of the main FCA handbook rules concerning AML systems and controls requirements. And I've also manipulated the filters here so that we can see all of the financial penalties for all of those cases after discount. And you'll see here on the right-hand side, it brings up 18 cases. And what's really interesting from this is that there are some huge cases against very well-known banks with very large fines involved. Eleanor mentioned before the Santander fine of nearly £108 million from December last year, and various other cases over the years, but there were only 2 of those 18 cases which involved individuals, which were specifically directed to individuals. And we can see that a bit more clearly if we click on this icon here. We can bring up a pie chart in the database which shows that only 11% of the money laundering related cases issued by the FCA since 2014 have involved individuals, and that was actually 2 individuals who both worked at, I think it was Sonali Bank UK. So my question to the panel, Sarah, George, perhaps you could start with responding to this, is given the sort of high the sort of high stakes, the big fines we're talking about and the big names with these fines, why aren't there more money laundering reporting officers and other directors and executives within firms who are being targeted by the FCA here? And can we expect to see more fines directed at individuals, perhaps via under the SMCR regime or whatever going forwards?
Well, the simple reason why there are so many more cases against firms rather than individuals is that firms always settle, pretty much, and individuals normally fight. So most of these cases will be settlements, and individuals who are facing the loss of livelihood, career, and hugely a substantial amount of money tend to contest these cases quite hard. It's also very often quite difficult to demonstrate culpability by an individual. And you don't often have the email correspondence or text messages or things that can attribute responsibility. Even within the senior manager's regime, it can be quite difficult. And there is a tribunal case going through at the moment, the Julius Baer case, which is very much looking at what level of responsibility on the part of an individual gives rise to culpability on the part of an institution. So I think that is the reason why you don't see very many cases. I think that there will be more cases against individuals. Particularly in relation to, because of the increasing number of money laundering cases, because of the sanctions contraventions, but they do take an awful long while to work their way through the process. I mean, 3 to 5 years to get from start of investigation to a tribunal case is not unusual.
Thanks, that's really useful. Sarah, Cody, do you have any comment on that?
Yeah, I mean, I agree with all of that. I think as well, I mean, what we do see is a lot of cases opened against individuals that are, subsequently dropped during the course of the investigation. So I don't think it's the case that the FCA isn't looking at the behaviour of MLROs and other senior managers. It's just that, as Sarah said, it evidentially it can be quite difficult to bring these cases. And I think also there is a sense in which often, you have to look at the broader picture within a firm, and it may be that an MLRO didn't have that much power. And I think, there's an optical issue, isn't there, of suddenly going after MLROs in the sense that nobody's going to want to take that job. So I think, there is a balance to be struck here between, targeting behaviour that is truly culpable and outside of what we would expect of someone holding that role, and looking at broader situations where actually, it's wider institutional failings that have caused the problems that the FCA have identified.
Thanks.
Yeah, I'd echo that. I think when you look at the large fines, they are well-funded, well-resourced banks with huge compliance departments, and despite what impression the FCA might give, people are genuinely trying their best to get things right in terms of AML, and so it's almost impossible to point the finger at an individual and say it's your responsibility. But things will change, and echoing what Sarah George said, as the FCA turns its focus to smaller firms, to payments firms, crypto firms, which are less well resourced, and it literally will be 1 or 2 people who are responsible for compliance or an AML particularly, be much easier to point the finger, and I think the failings will be more stark than for large firms who genuinely know what they're doing.
Thanks, all. That's really interesting. We've got quite an interesting question which has come in Does the panel think that the proposed extension of failure to prevent offences to, for instance, fraud, money laundering or false accounting, noting this is still to be confirmed, might give the FCA further impetus to enforce the money laundering regulations or other relevant financial crime systems and controls requirements? Rob, do you want to take that perhaps?
Well, I mean, the short answer is yes, although maybe not in pursuance of that particular piece of legislation. But historically, we've had a very fragmented approach in this country to dealing with financial crime issues, and that approach is not being addressed by the stuff that's currently going through Parliament, and will continue to have that. The FCA and other regulators, the prosecutors, are always keen to try and cooperate where they can, but the reality is they all have their own remits, they all have their own standards against which they're judged. And the direction of travel, clearly, as going right back to the very beginning of this session, is the FCA is looking very hard at all of these financial crime issues and thinking that it might do more in that space. And so, it's kind of part of the zeitgeist, I think, and that is just going to continue. And I think that the legislation going through Parliament, the light it shines on the way we do those sorts of things in this country, is just going to move that agenda forward and continue to do so.
And Rob, seeing as you've just spoken, I'll get you to speak again on, you mentioned PRA enforcement briefly before, but obviously with your background, you're best placed to sort of, can you give us some guidance about how we can see PRA enforcement sort of going forwards, going ahead? Obviously, there haven't been many cases coming out of the PRA in the past. Can we see that changing in the near future?
So they have quite a few investigations ongoing. It's just that on a sort of year-by-year basis, they don't conclude that many, because it's a relatively small team by comparison to the FCA's enforcement division. So in that context, it's understandable there aren't that many cases. What tends to happen with the PRA cases is they tend to follow a kind of fairly sort of well-worn path, which is the PRA has got certain priorities that it tends to set out in its supervision portfolio letters. And when then you look at the enforcement cases, and quite often they tend to follow those particular priorities. So, for example, at the moment there's a pretty big push on outsourcing and third-party risk management, things like that. You could see the PRA wanting to wade more into that space in an enforcement context. There's nothing like a big operational failure. Going back as far as 2014, in fact, the PRA's first enforcement case was on a big operational failure in a major institution. So in that context, I think we'll see more of that. There's also what I used to call, when I was at the PRA, the sort of murder is always in side to the enforcement regime, which is the integrity and the misleading the regulator cases are always high priority to be taken regardless of where they arise. And so whilst you can't necessarily point to the PRA having a sort of laser focus on a particular area in the same way as, for example, the FCA might have in the consumer duty context, I think you can sort of derive some direction of travel from what the PRA is saying publicly about supervision priorities, plus the, don't do stuff that's low-hanging fruit kind of element to the cases.
You mentioned operational failure, and someone has asked, in terms of operational resilience, there's only really been one major case coming out of the FCA and PRA, which was, of course, TSB at the end of last year. How can we see that going ahead? Are we expecting more operational resilience cases on the horizon? Guy, maybe that's one for you.
I think so. I think, that is the only case specifically in terms of operational resilience, but that really came out of poor project management and change control. And there have been other cases where firms, I think the City case, firms are criticised for insufficient or poor project planning, insufficient resource into implementing changes, and so the FCA is and the PRA are not afraid of taking cases against firms where there's every intention of complying with the rules, and firms may have tried to comply with the rules, but because their planning was poor or resourcing was poor or decision making around project planning was poor, the outcomes were bad, and therefore the regulators will step in.
Thanks, Guy. And picking up on what Sarah was saying earlier about the SM and CR, we've had another question around the SM and CR. With the government's announcement of the Edinburgh reforms and the planned review of SM and CR, there has been much discussion about the lack of enforcement actions under SM and CR being an indication that it is simply not working. Sarah, what are your thoughts on that? Sarah George, sorry. Yeah.
Sorry. I mean, it's very difficult to say that something's not working when it, is the motivation for bringing something in to actually bring more enforcement cases, or is it actually to make people conscious of their responsibilities, obligations, and duties? So actually, I think it has had the opposite effect. I think it has been very influential in changing the way senior managers think about their obligations, their duties, the fact that they have to map out their responsibilities. I think it really has been a sea change in attitude. So I don't think it was brought in with the intention of creating, a few cases in the tribunal. I think it was brought in to create a fundamental sea change in attitude. I think it's done.
Yeah.
Thanks, Sarah. So, yeah.
I might just add to that. I think there's a rhetoric issue and then there's a practical issue, right? The rhetoric around the SMCR was always, more enforcement, more enforcement. The reality is that it's been an amazing supervisory tool, which the regulators deploy every day of the week, hundreds of times, to get senior managers to do what they want them to do, both in informal ways and in terms of getting attestations and all of the stuff that goes around that. So I'm absolutely with Sarah. I think it's made a real difference to the way that firms operate. You just don't see it necessarily above the waterline as much as perhaps the rhetoric might have suggested at the beginning.
And I think, it's a very powerful tool in the context of reg change as well. I mean, looking at things like the consumer duty, although they haven't given that reg responsibility for implementation of the duty to one senior manager, it's clear that there are enhanced obligations under the duty for senior managers. And it's a very useful tool for the FCA to be able to say, okay, senior manager, what are you doing in this respect in your business area? Because you've got a reg responsibility here and you need to be meeting these obligations. And I think just being able to pinpoint those point people in an organization where you have diffused responsibilities and lots of people doing lots of different things, it's actually, I agree, it's incredibly powerful. I think many people were a little baffled by the singling out the SMCR as something that might need a review when the Edinburgh reforms came out. So I think it will be interesting to see what they do. But I would agree. I think it's a misnomer to think that lack of enforcement means it hasn't done what it was supposed to.
I think, echoing something Sarah just said, I think there are echoes here with the consumer duty when it comes in. There is an expectation, like there was with the SMCR, there'll be a huge explosion of enforcement. I don't see that. I think firms, by and large, are taking consumer duty very seriously. They are changing their processes in accordance with that. And yes, there will be some enforcement cases involving poor consumer outcomes and detriment, but they will be the very much the worst cases. And I very much doubt that the sorts of cases that could not have been brought under the existing regime, but the FCA will chuck in breach of consumer duty as an additional failing alongside whatever other rules they find. So, but like the SMCR, consumer duty will feature in supervisory interventions more, and including more OIREX, VREX, and the rest of it.
Thanks all, that's really helpful. Moving on to something slightly different, something which is very trendy at the moment, ESG. Someone's raised a question around greenwashing. There's a huge interest in greenwashing, both by UK regulators and internationally, with 2 Dear CEO letters being published by the FCA within the last month, warning asset managers and benchmark administrators to mitigate against the risks of greenwashing. How do we see this cutting across to enforcement? Sarah Cody, do you have any thoughts on that?
Yeah, so I mean, I think the potential for a raft of mis-selling cases around greenwashing is obviously very clear. It is a particularly difficult one, I think, because the sorts of metrics that you use to prove your green credentials for your fund or your whatever investment activity you're doing aren't agreed. There isn't a consensus as to how you actually benchmark these funds, and there's no one agreed definition, I don't think, even within the UK, let alone the UK versus the EU or other jurisdictions, as to what is green and what you have to do to meet these standards. So there's an incredible amount of subjectivity, which firms are going to have to be very careful about navigating if they want to avoid or sort of mitigate this risk. It does also kind of wrap into the sort of the customer understanding outcome under the duty, in terms of that need to be communicating the green credentials or otherwise of your fund in a way that doesn't exploit bias, doesn't exploit vulnerabilities, and is actually well understood by the people that you are targeting this product at. So there's quite a lot of moving parts here. Obviously, we haven't seen any enforcement action in this space yet, but it does definitely feel like it's something that could very easily begin to pick up speed. And I think as the fact that the FCA is publishing, as you say, that the CEO letters in this area shows that it's obviously a concern. So it's definitely something to be thinking quite carefully about, and particularly the new labelling regime that will come into force in about a year, I think will be a really important tool for the FCA, and at least gives a degree of standardization, but I don't think it's going to solve some of the sort of inherent tensions for firms in trying to get this right.
Sorry, thanks, Sarah. Would any of the other panel members like to comment on that?
Yeah, no. I'd echo what Sarah said. I think it's very difficult, I think, for the FCA to pick an appropriate case, because firms are naturally very careful what they say and try as much as possible to just rely on objective information, such as we've been assessed by this external body as being compliant with whatever level it is. And so, because firms are careful and it is a difficult area, I think finding the right enforcement case will be difficult for the FCA, unless they just pick on some tiny little firm that's just got it completely wrong. But are they really going to do that? I don't know.
Thanks, Guy. We haven't got time. We've only got about 6 minutes left, and unfortunately, we haven't got time to cover all the questions, but there are just a couple which I'd like to touch on before we end. The first is around the topic of market abuse, which we haven't really dealt with that much today. Someone has asked, a few days ago, the FCA and Her Majesty's Treasury announced that they completed a review of the criminal market abuse regime and aim to replace it with UK-specific legislation. Can the panel comment on whether they think market abuse is going to continue to be a priority focus for FCA enforcement, and are there any particularly new developments of note in this area which firms should watch out for?
Well, I can answer the first part of that question. I think yes is the short answer to that. I mean, it feels to me like the market abuse and insider dealing regime in the UK is probably well overdue an overhaul, in the sense that it dates back sometime into history. And so in that context, it's kind of understandable that that's where the government and the FCA are going. Interesting to see where it ends up. I haven't engaged with it that fully, but when you look at the enforcement cases that there have been over the last year or so, there have been a fair number of market abuse related cases in there, and both in relation to firms, but also in relation to at least one individual. So I kind of feel like that is likely to continue. Going back again to the very beginning conversation we had around the dual-headed nature of the enforcement division, now that you can kind of see why that would continue to be a priority.
Thanks, Rob. Guy, yeah.
I think the big change will be expanding the scope into new markets, because in the past it's been very equities focused, and the FCA has been interested, but I think unable to take action in the case of people using political inside information to then speculate on FX markets, which doesn't fit a standard market abuse definition. So it's been difficult to take action in those areas.
And last question, are there any other anything else which the panel think that we should have touched on today for 2023 and beyond that we haven't mentioned that people might want to think about?
I mean, culture has been a hot topic for the past few years. The FCA keeps kicking into the long grass its paper on and draft rules around diversity and inclusion in firms, but there's no doubt that that's still a concern, and the link between cultural failings and customer harm has been well made and continues to exist. I think that will be interesting to see what the new heads of enforcement do with that particular remit. I think it's been a priority of parts of the FCA, maybe not enforcement so much, but it will be interesting to see where that goes with new people in charge in terms of whether it becomes an enforcement rather than a supervisory focus, which I think it will remain.
And the non-financial misconduct agenda, I guess, is another one where I think we're going to continue to see that sort of, moving things forward in enforcement context. I mean, it's still, I can't speak for everyone on the call, but I'm sure the experience is the same. It still occupies a lot of headspace for clients that I'm dealing with in terms of trying to figure out where they stand in relation to those sorts of issues.
Yes, I agree with that. I think it's the sheer variety of fact patterns that arise in a regulated firm on non-financial misconduct, and trying to apply the very, very lengthy decision-making process the tribunal used to those facts is incredibly difficult.
There was a hint in some FCA board minutes that they were thinking about guidance, but whether that materialises or not is another question.
Okay, well, we're coming up to the hour. I'm sure everyone will agree that it's been a really informative session, and I'd like to give a very hearty thank you to Sarah Cody, Sarah George, Rob Dedman and Guy Wilkes for their time and expertise today. We will be sending out follow-up emails to all those who attended, and we're also intending to circulate an enforcement trends report in the next 2 or 3 weeks, so please do look out for those. As I said, the session was recorded, so we will be posting the video online. Thanks again, and we hope to see you all soon. Goodbye.